Okay, we're going to jump into the chapter on employment law. This is an area where many of you will have had some experience in your jobs with different aspects of employment law, and some of the things that we're going to cover today you'll be familiar with from your jobs and your own work experience. The first is the idea of employment at will. And the employment at will doctrine basically means that your employer can fire you for any reason. It could be a good reason, could be a bad reason, or it could be no reason at all. And it's legal to do that. So if your status is as an at-will employee, then you are subject to being fired by your employer again for any reason, good, bad, or no reason at all. This differs state by state. So some states have adopted the employment at will doctrine. Some states have not. Some states are hybrid. Georgia, I will tell you, is an employment at will state. So those of you who work for employers in Georgia are subject to this doctrine. Now, the rest of the chapter is going to cover exceptions to the employment at will doctrine, and we'll see that that doesn't mean that you could not be fired for discriminatory reasons. There are federal laws against that, but the state law base is that employees can be fired for any reason. So, for example, if my boss is an Auburn fan and my boss finds out that I'm not an Auburn fan, that I'm a Georgia fan, and Georgia beats Auburn, and I come into work on Monday and he fires me because of that, if I am an employee who is subject to employment at will, then that is not illegal for him to have done that. That does not mean, again, that I couldn't be fired. I mean that I could be fired illegally for my age, for my race, for my religion, for disability, and so on and so forth, things that we're going to talk about in this chapter. But that's just to illustrate sort of a reason that somebody could get fired that would actually be legal, but that was not a good reason. If you have an employment contract, then that takes you out of employment at will status. So many of you have signed contracts, and so those contracts themselves specify what you can and can't be fired for, and your employer is bound to follow those things. And if your employer fires you for a reason that is not provided for in your contract, then that would be a breach of contract, and you would have a remedy at law for having been fired for a reason that violates your contract. So that's one of the main ways that folks get around being an employee at will, is that they either work for somebody who uses employment contracts, or they insist on employment contracts. Some states also recognize this idea called wrongful discharge, and that means that, again, I can't give you a specific state statute on that because it could differ from state to state on what constitutes wrongful discharge. But just know that in some states, there are limitations on the employment at will doctrine based on other laws that a state may have passed that limit the reasons that an employer could fire an employee, without cause. We have federal law, so the employment arena is mixed with state law and federal law, as you've already seen from this lecture. We have laws that govern hours that an employee can work, how much an employee, the minimum wage that an employee can be paid. Those are federal laws. We have laws governing child labor. Those are federal laws. We have laws governing overtime. So some of you may have encountered that. And the overtime federal law basically says that if you work more than 40 hours in a week, if you work more than 80 hours in a 2-week period, then any hours above and beyond that, you are entitled to be paid time and a half for that. So that applies to not every employee, unfortunately. It only applies to certain classes of employee. So managerial employees, executive level employees, salaried employees, that does not apply to. However, I will caution you that if you are unsure about whether your job is classified correctly, you should look into that, because there are many times that an employer will classify a job as being exempt from overtime, meaning they don't have to pay you overtime, when in reality that job should be an hourly job that is eligible for overtime. So just because an employer classifies a job as exempt from overtime, that's not the final say. The overtime and wage and hour laws specify the types of jobs that are eligible for overtime and the types of jobs that are exempt from overtime. So it's not necessarily how the employer labels it, it's how that job fits on a case-by-case basis within the criteria that the law lays out for whether a job is eligible for or exempt from overtime. So if you think you're in a job that really should be eligible, but your employer has classified it as exempt, then you need to look into that. And remember that employers have every incentive to classify a job as exempt, because that way they could work those employees in those jobs more than 80 hours in a 2-week period and not have to pay them overtime. So it would behoove the employer in those close call situations to err on the side of classifying a job as exempt. Family and medical leave, we'll talk about that for a second. That applies to employers who have over 50 employees, and it applies to employees that have been working for that employer for 12 months. So employers with less than 50 employees don't have to provide family and medical leave, and if you have been in the job for less than 12 months, and you're not eligible to get it. But what family and medical leave covers is that it allows any eligible employee to take up to 12 weeks of leave within a 12-month period to care for new children, to care for adopted children, to care for foster children, to care for themselves if they're ill or they have some sort of injury or medical reason why they need to be out of work, if they have a serious health condition, to care for a seriously ill parent, spouse, or child, and if they have to miss work because a parent, spouse, or sibling, or child is on active duty with the military, that could be another reason that a person could seek family and medical leave. So another thing to remember about FMLA is that it is unpaid. So yes, you get 12 weeks off of work, but you are not paid your salary during that time. You are entitled for the employer to continue your benefits, such as health insurance, so that you don't have to worry about being uninsured during the time you're out on leave, but you're not going to be paid. You will get your health insurance, but you won't be paid. You're also guaranteed that at the end of your leave, when you come back, you're guaranteed that you'll either be placed in your same job or in a similar job in terms of duty and pay. So an employer is required to do the best they can to put you back in your same job. And if for some reason they couldn't wait, they couldn't leave your job open during those 12 months, or for whatever reason it's not available for you to come back to in 12 weeks, then they're required to put you in a similar job, a similar status, title, pay, and that sort of thing, with the main idea being that you're not going to be penalized or docked any status, seniority, or pay because you had to be out on medical leave. One interesting thing right now is that I'm recording this video in November of 2021, and so as recently as this past weekend, the House of Representatives passed part of the president's legislative agenda, and that version of the bill passed by the House includes at least 4 weeks of paid medical leave. And so they've still got to work that out between the House and the Senate as to whether that makes it into the final version of the bill that will get it put in front of the president for him to sign. But as of now, the amount of leave that you could get paid for could change, and that might not be the case by the time that the semester is over. We may have a new law on family and medical leave. So just know that that's an area of the law that's changing rapidly and as we speak. So that's family and medical leave. Some of the federal statutes that protect worker safety and workplace safety. The Occupational Safety and Health Act, you're probably familiar with OSHA, the acronym that they go by. And these are the folks that mandate certain safety conditions. They mandate certain notice requirements that employers are to give employees about their rights under under this law, and it applies to employers with 11 or more employees, and that would trigger them to be subject to certain safety standards, certain notice provisions, and certain reporting provisions. So that would trigger that employer who is subject to these requirements to make reports anytime there has been any violation of the standards, or if there have been any accidents or workplace safety events that need to be reported to OSHA. It also subjects these folks to inspections, sometimes surprise inspections, and that sort of thing. An employer cannot discharge an employee for making a complaint to OSHA, a safety complaint. That's not something that a person could get fired for. Workers' compensation, you've probably heard of this. Hopefully you're not familiar with it from a personal perspective. I hope no one's been injured on their job. But if you are injured on the job, then state workers' compensation laws will then cover how you're to be compensated for those injuries, how long you can be compensated for those, how long you can be out of work, all those sort of things. And that is done. So whereas OSHA, Occupational Safety and Health, is a federal law and administered on a federal level by a federal agency, workers' compensation laws are all state-driven, and they are overseen by state boards of workers' compensation. So the law on OSHA is the same from state to state because it's a federal law, but the law on workers' compensation will differ from Georgia to Alabama to Tennessee to South Carolina to Alaska and so on. COBRA, I'll just mention real quick, you should all know that certain employers are required to offer you the chance to continue your health insurance if you leave the job, either voluntarily or involuntarily. And so you would need to, your employers, they all know this and they'll get with you. Typically, it's really expensive and most folks opt not to do it, but it is an option for you if you're worried about not having health coverage while you're in between jobs. Then COBRA is certainly something you can take advantage of. Getting unemployment pay, that is also much like workers' compensation. That's a state-by-state basis. So the law about what you can get in terms of unemployment benefits in Georgia, how long those go, so on and so forth, those are state laws, and so they'll differ from state to state. And also the state unemployment law will cover the criteria for whether you're eligible or not for unemployment. Let's see. Next, we're going to talk about employment discrimination. This is probably the most important topic and thing that I want you to appreciate from this chapter. Employment discrimination is federal law, and it comes from many different sources that we're going to go through. And it protects, we're going to go through all the different classes of people that it protects. But you'd be familiar off the top of your head with, it protects you from being discriminated upon the workplace on the basis of race, national origin, religion, disability, age, veteran status, all those sorts of things. So if you fall into one of these categories that is protected from discrimination on that basis, we call those protected classes. And so we may be members of more than one protected class, for sure, depending on our certain circumstances. So the way that a discrimination case works is that it would be up to the employee to come to court if you're going to sue for employment discrimination. The employee would have to establish some things up front. So the employee would have to show, let's say that I'm going to sue Columbus State for discrimination on the basis of age, which I am qualified to do because I'm over 40. And so let's say I had an age discrimination complaint against them because I felt that they did not give me a promotion because they felt that I was too old for it. So I'd have to prove, number one, that I was a member of a protected class. So if I'm suing on the basis of age discrimination, the law says I got to be over 40. So am I over 40? Yes, I've proven that I'm a member of that protected class. I'd also have to prove that I was qualified for the job that I applied for and was turned down from. I could get, certainly I could claim age discrimination as a reason I didn't get a job, but if it was also a job that I was never qualified for in the first place, then that would disqualify me from suing for discrimination. So I'd have to so I'm proving those two things, that I'm a member of that class, that I was qualified for the job, and that I was rejected for the job. So those are the three things that I would throw out first. And then it's called burden shifting. So in every case, like you think about your typical criminal case, the burden is on the state or the prosecutor to prove that the defendant is guilty beyond a reasonable doubt. The defendant doesn't have to prove anything in that case. In employment discrimination, it has sort of a hybrid model. So like I just laid out for you, the employee has to come forward and prove these threshold issues. And at that point, the burden then shifts to the employer. And the employer has to assert for the court a non-discriminatory reason that the employee had the action taken against them. So if I was not promoted, then at this point in the case, CSU would have to come forward with a reason that I wasn't, a legal reason I wasn't promoted. They could say, he hasn't been here long enough. He didn't score highly on the test. He did poorly in his interviews. He's got terrible performance reviews. His students can't stand him. Those sort of things. He comes down too hard on students who cheat. All of those might be reasons that they would throw out. And so once they've done that, then the burden shifts back to the employee, in this case me, and I would have to prove that the reason that they gave was pretext for discrimination. What that means is that I would just have to say, look, I'd have to prove through evidence and testimony to the jury and the judge that the reason they gave was not the real reason. And I could show that, hey, as it turns out, my interview scores were the top scores, that I was the most qualified of the applicants, and therefore I'm shooting down the reason that they gave. So basically I've got to prove that the reason they gave was bull. That's the best way I can put it to you. The employer puts up a reason, and it's up for the employee to prove that that reason was bull. If I can do that, then I can succeed at an employment discrimination case. Before I go to court, should back up for a second and say that before you sue your employer in court for employment discrimination, you have to file a complaint with the Equal Employment Opportunity Commission, the EEOC. And that is just a prerequisite step that you have to take. Sometimes the EEOC will investigate it for you, and they will decide that they will take the case and they will make the case against the employer for you. Those are great. They don't happen very often, but in real egregious cases or in cases of class action when a decision by an employer has affected a large class of people and it's something that the government wants to get involved in, then they'll take your case for you. But they could either take your case, they could decline to take your case, they could, no matter what action they take, you still can sue your employer. And so it's really many times just a preliminary step that you have to take. Once you've done that, they'll give you what's called a right to sue letter, sort of like your ticket to Hollywood and American Idol. They give that to you, and then once you have that, then you can go sue your lawyer and you can file a lawsuit against your employer. Discrimination tends to fall into two different types in terms of the way it happens. And I don't mean in terms of protected classes, but in terms of the way that it affects an employee. So there are disparate treatment discrimination cases and disparate impact discrimination cases. A disparate treatment impact case, I'll mix those together. A disparate treatment case means that an employee was treated differently than another employee based on one of the protected classes. So an example of that would be, I was treated differently in my age discrimination case than other employees who are younger than me. I didn't get the job, a younger employee got the job, and it was because of my race. So treatment cases are one versus one type cases or one versus others type cases. Disparate impact, on the other hand, is when a policy of an employer might be neutral on its face, but it ends up having a discriminatory effect on the pool of applicants or upon the employees who have suffered the adverse employment action. So, for example, that would be, let's say that that an employer wanted to hire for a laborer position, and they required that all applicants have to be able to drive themselves to the interview. So on its face, that policy is not discriminatory. Yes, that would have a discriminatory effect on people who can't drive, but it's not against the law to discriminate against non-drivers. Okay, so this policy is facially neutral when it comes to discrimination. But let's say that as a result of this policy, the area that the employer is hiring from has a high percentage of residents and available workers who are immigrants, and that who don't have vehicles, or there it's a socioeconomic class that includes a high number of immigrants or minorities who don't have cars. So the effect of the policy is that a number of the population in the surrounding area that the employer would pull from is not eligible for that job and is being excluded from that job. And even though the policy on its face was neutral, the impact of it, or the effect that it had on the hiring, was discriminatory. And so that is a way that that a policy can be discriminatory on a basis of disparate impact. So treatment is more one-on-one. I was discriminated against in the situation vis-a-vis another person or another group of people. Disparate impact is I'm a member of a class who was impacted in a discriminatory way by an employer's policy that might not have been discriminatory on its face. Let's talk about some different protected classes and which law these protected classes come from. So Title VII of the Civil Rights Act of 1967 covers many protected classes. That's where we get race, color, national origin, those sort of things. And Title VII makes it illegal, of course, to discriminate on the basis of these things. But I want you to realize that these protected classes cast really wide nets. They're not narrow. They're not narrowly drawn, and the courts do not interpret them narrowly. So a person might be discriminated against based on their color. That doesn't mean that the person is a minority, such as an African American or Latina or Guatemalan or Greek or something like that. They might be a Caucasian person with a dark complexion or with a medical condition that affects their color in a way that is unusual or different from maybe what the employer would consider normal. That's still being discriminated against on the basis of your color. So it's more of an appearance thing. Well, I don't want to mislead you. Certainly, if race is the basis for it, and often these go hand in hand, then color does go with race. But I want you to know that just because somebody is discriminated on the basis of color doesn't necessarily also mean that they had racial discrimination as well. But most of the time, those would go hand in hand. Ethnic characteristics. If somebody thinks that I look Jewish, or that I look foreign, or that I look Russian, that would be discriminatory, even though I might not be foreign or Jewish or Russian. If I'm being regarded as that based on my appearance, then that would be protected by Title VII. National origin, of course, refers to a country of a person's birth or their ancestry or their culture. All those can be included in these things. So discrimination based on a cultural practice of a race certainly could be national origin discrimination. So these are really wide categories. Those are all Title VII categories. Religion is also a Title VII category. You cannot be discriminated against on the basis of your religion. And so in a disparate treatment case, that's easy to think of. I can't say that, Tom, we didn't hire you because you're Jewish. We didn't hire you because you're Methodist. We didn't hire you because you're Muslim. Those are obvious disparate treatment cases. But a person can be discriminated against on the basis of religion if the employer refuses to provide accommodations for that person's religion. So, for example, if my religion required me to wear a certain headgear or a certain garment, and the employer refused to let me wear that, then that would be discrimination on the basis of religion. The requirements are that it can't be unduly burdensome on the employer. So it's not a blanket reason for an employee to just make all kinds of demands for accommodations. They have to be reasonable. It has to not make an undue burden. So, for example, if I had somebody that wanted to work for my law firm and they said that their religion, they needed an accommodation for their religion that only allows them to work between sundown and sunup, that would create an undue burden for me because my law firm is not open during those hours. And so I would not be required to accommodate that. But let's say that I had an employee who was of the Jewish faith and they required certain high holidays within the Jewish faith to be off, then it would be employment discrimination under Title VII for me to refuse those days off for those accommodations. Now, you might be thinking, I'm going to come up with a really good religion that I'm going to make up a religion that allows me to be off on Mondays and Fridays, and my employer will be required to accommodate that. It has to be a sincerely held belief. And so you can't just make up a religion on the basis of trying to get some free days off and so on and so forth. So it would have to be something that you sincerely believe. And you can certainly see how court cases could get involved in that way. I mean, if I just come in with a BS reason to CSU why I can't teach on Mondays and Fridays because I've got this made up religion. But what if I go to my church every Sunday and there's 5 of us and we've written out all these rules of our religion and we all follow them and we all worship something that we've made up and we sincerely, is a religion that 5 people follow a sincerely held belief. Is 2 people enough? So you can see where courts would certainly have to get involved in some of these closer calls. Discrimination based on gender is also a violation of Title VII. And so obviously that means that you can't not hire or not promote or fire somebody because they are a man or a woman. You certainly cannot take an adverse employment action against a woman because she's pregnant. That's why we advise employers in job interviews. It is unlawful to ask an applicant, female, if she is pregnant, if she's planning on getting pregnant, what her, how many kids she wants to have. All of those would set an employer up for an employment discrimination case if they didn't hire that person, and it could be proven that they didn't hire them because of whatever answers they gave to that pregnancy question. Your book is going to tell you that sexual orientation is not a protected class. When the book was written, that was true. But since the book has come out, the Supreme Court has decided in a case called Bostock versus Clayton County that Title VII gender discrimination does include sexual orientation. And that is a case that I've assigned to y'all in this content module, and there's an assignment on it. So you'll be reading a case that actually is from Georgia that went all the way to the Supreme Court, and it is the case that changed the law with respect to whether sexual orientation is included as a protective class for discrimination under Title VII. And that is a relatively, of course, as I said, I think it's a 2019, summer of 2019 case. So that's something that has changed. I would expect the Supreme Court to be hearing cases in the near future on transgender, some of these other areas of the law that go along with the ideas of gender and sexual orientation and sexual identity and those sort of things. I would imagine that as we go along, that the Supreme Court is going to include all of those in Title VII as well. So that's an area to certainly look out for. Sexual harassment is illegal, and you certainly probably, hopefully none of you experienced it, but it's certainly something that is in the news with the Me Too movement. You see it in movies and TVs and books and that sort of thing. There are two kind of types of sexual harassment. One is quid pro quo. That means in Latin literally something for something. So that kind of sexual harassment is your boss says, I will give you a raise if you have sex with me. I will, I'm going to report you, or I'm going to give you a bad performance review unless you flash me, or unless you send me a naked picture of yourself, or something crazy like that. That's quid pro quo, something for something. The other kind is hostile work environment. And so hostile work environment means that nobody said that anything was going to happen to you unless you did something. What that means is that you work in a place where comments are made about yourself, sexual comments, or about others, where jokes are made, where there's physical contact, where that kind of thing has gone on to the point where it's offensive and it's pervasive in your work environment. Hostile work environment also can extend not just to sexual harassment, but to race, religion, and all of these other areas that are protected under Title VII. So if I'm in a work environment where, let's say that I'm Methodist and everybody continues to make jokes about Methodism, where I feel that it's just a hostile environment for a Methodist to work. I know this is a silly example, but just to illustrate, then that could also be a hostile work environment as well. Title VII also protects an employee from retaliation, from making complaints about any area that they feel like that they're protected under Title VII, or if they've been harassed, or if anything's happened to them for reasons that are discriminatory. So an employer cannot fire you, demote you, dock your pay, give you a different job because you have made a legitimate complaint against them. That would be retaliation. Discrimination based on age, that is actually not a Title VII protected class. That is under its own law called the Age Discrimination in Employment Act. It's another federal law, and it protects any individuals who are 40 years of age or older. So we often think about folks being discriminated against because they were too old for a job, and we think about individuals who are on the higher end of the age scale, maybe over 50 or in their 60s. But actually, once you turn 40, you are protected against age discrimination by the ADEA. Discrimination based on disability has its own law too. That is the Americans with Disabilities Act, or the ADA. And so again, you cannot be hired, fired, not promoted, or had any adverse employment action taken against you, or have a hostile work environment for any reason based on your disability. So again, disparate treatment discrimination would be, I wasn't hired because I have a disability. I wasn't promoted because I had a disability. I was fired because I had a disability. But similar to how employers must accommodate religious requests, employers must also accommodate requests for accommodations by those with a disability. So if I work an information desk in the mall, and it's generally a standing job, but I need a stool because I have a disability related to my ability to stand for long periods of time. That is an accommodation that the employer would have to make for me, or else I would have been discriminated against. So we're going to talk about some exceptions to that in a minute. But the general idea is that if I need an accommodation to help me do my job, then the employer is required to do that for me. As you might imagine, if you've learned anything from this class, it's that in the interpretation of the law is varies between person to person, it varies between court to court, varies between state to state, and law to law. So what actually constitutes a disability is an area that we have had just reams and reams of litigation about over the years. The one that we're most familiar with, the disability, would be, a physical or mental impairment that substantially limits one or more major life activities. Well, I require a wheelchair to move around. I'm not ambulatory. That's an easy one for us to see. But when you get into that definition, well, what is a mental impairment? What does it mean to say that my impairment substantially limits? What is substantial? And what is a major life activity? Those are all things that have gone through the court system, and so we've developed just books and books of case law about what constitutes a disability. I might not be disabled today, but I might have a record of disability. And so that would fall under the definition of disabled for the Americans with Disabilities Act. So say that I used to suffer from seizures, but that is something that I don't suffer anymore. If my employer regards me as disabled because of that, or treats me differently because of that, then I still could fall under the class of disabled folks. Even if I don't have an impairment, if my employer regards me as having one, or treats me as having one, perceives me as having one, then I could fall under the definition of a disabled person under the ADA. The accommodations have to be reasonable. So going back to the idea about the religious discrimination having to be reasonable as well, same thing. An employer would not be required to make an accommodation that would cost so much that the employer couldn't be profitable, or that would shut the employer down. So you're not required to make an accommodation at any cost. The law observes and understands that there are certain limits to what an employer should be expected to pay for an accommodation. It's a case-by-case determination, as you might expect, and also, as you might expect, there are plenty of cases on what constitutes an undue hardship or not. Some defenses to employment discrimination. So what are some ways that employers can make some decisions that are legitimate employment decisions, but that might otherwise be viewed as discriminatory? So one of them is that if there is a business necessity. So if I want to have, if I'm a restaurant and I'm a fancy restaurant with restroom attendants, it would be a necessity for me to have male attendants in the male restroom and female attendants in the female restroom. If I'm a clothing company and I'm hiring models, it's okay for me to only hire females to model female clothing and males to model male clothing. If I am, if I have a job that requires anything sensitive to either gender, then it'd be okay for me to, just hire that gender. If I am at a Catholic school and we only are going to hire Catholic nuns to teach in our school, that's permitted. So there are some bona fide occupational qualifications that could be permissible in making employment decisions. Seniority systems are legitimate, and non-discriminatory. So if you hire according to seniority systems, in other words, when the promotion is available, we follow a practice of giving it to the employee who has the most discrimination, the most seniority. Then, so yes, maybe a younger person got hired over me, but that person had more seniority. Maybe a male got hired over a female, but if the male had more seniority, then that would be okay. Maybe I got hired over someone who is from another country, but because I have more seniority, that's okay. Now, an employer can't pick and choose when to use that. It has to be a practice that they follow and that they stick to. So it's not something that you could just do on a case-by-case basis. If you're going to promote or hire based on seniority, and in order to be protected from discrimination claims, then you would need to have a good record of sticking by that. That is generally what I want you to know about employment discrimination and the employment content in your text. This is an important area that I want you to read and study. The quiz and the assignment and the part of the final that will cover this will give you scenarios where so-and-so got fired for this reason, or so-and-so requested this accommodation, and you'll be expected to know whether or not that was a violation of a federal or a state employment law, or which one, and of course, as always, why that was a violation. So, you could expect to see certain questions like so-and-so was fired. Was this legal? Yes, because. No, because. And you'd have some choices to make along those lines. If you have any questions about any of this content or anything on the assignments or the assigned cases for this particular chapter, then please let me know.